Welcome, everyone. My name is Jim Calloway. I'm the director of the OBA, Oklahoma Bar Association Management Assistance Program. And today I have a great group to do our video roundtable on lawyers, artificial intelligence, and the ethical challenges of using AI. Again, we've got a great panel here. Damien Riehl is a technology lawyer who clerked for state and federal judges, litigated for 15 years, helped companies with cybersecurity, and currently helps VLEX extract and generate valuable insights from a data set of only 1 billion documents worldwide. At Sally, the legal data standard he helps lead, Damon has built and expanded an ontology of over 14,000 legal tags, effectively standardizing legal data. And in August, his big claim to fame, Elon Musk posted about Damien, "This guy rocks." So
not bad.
Thank you, David. Welcome. Ivy Gray is the Chief Strategy and Growth Officer for WordRate. Before joining that team, she practiced bankruptcy law for 10 years. In 2020, Ivy was recognized as an influential woman in legal tech by ILTA, and she's been recognized as a Fast Case 50 honoree and included in the Women of Legal Tech list by the ABA Legal Technology Resource Center, our sponsor today. Hi, Ivy. Jayne Reardon provides ethics and regulatory advice to lawyers and legal service providers as a principal of Jayne Reardon, LLC. She serves as a neutral in mediation and arbitration proceedings. An experienced commercial trial lawyer, Jayne sits on national rosters of the American Arbitration Association for commercial and consumer arbitration and is certified as a neutral in early dispute resolution process. Jayne is a nationally renowned expert on legal ethics and professionalism. She recently joined Fisher Boyles as Deputy General Counsel. Previously, she served as Executive Director of the Illinois Supreme Court Commission on Professionalism and as Disciplinary Counsel for the Illinois Attorney Registration and Disciplinary Commission. And I might also add, Jayne has served a stint on ABA Tech Show Planning Board. Kenton, go. Hi, Jayne. Kenton Brice is the director of the law library at the University of Oklahoma College of Law. After practicing law for 6 years, he began his academic career at OU Law in 2015 as the law library's first digital resources librarian before transitioning in 2017 to become the college's first director of technology innovation. With a focus on building and expanding the college-wide digital initiative, he created the OU Law Center for Technology and Innovation in Practice, establishing OU Law as a leader in innovation and legal education. Kenton is a member of the 2018 class of Fast Case 50, and thanks to his effort, the college was the first law school in the world to receive the Apple Distinguished School Award and has been listed as a top 25 most influential law school multiple times. And Kenton Brice is also an alumni of the ABA Tech Show Planning Board. Welcome, Kenton.
It's great to be here. Thanks, Jim.
Okay. Well, the plan here is just to have a discussion, me and 4 people who are all smarter than me, or 5, of the AI and ethics and whatever. We more style this rather than a CLE program, as if the 5 of us all got together in a coffee shop and started talking about AI and the things we'd seen this year. So let's go ahead and get started. We're going to start with Ivy. So Ivy, why is it that these new generative AI tools feel so different, even though we've been using AI in law for decades?
So the biggest difference here is that in the past, you had to be an expert to use expert tools. Now, you don't have to know anything to get something from ChatGPT or a lot of the other generative AI tools. It used to be that to do legal research, you had to be trained on legal research and understand Boolean search logic. To use corrective AI, you had to really understand grammar. To use collaborative AI, you also had to know the expert tools and it would guide you through that. Now you enter something and you get an answer. Even more importantly, though, you don't have to go through IT or procurement to get access to these tools. So there aren't any gatekeepers. And if you don't have good judgment about technology, which I think Model Rule 1.1 Comment 8 was meant to guide you toward, if you don't have that good judgment, you can easily end up in a world of trouble. So I think that removing those barriers to entry and just letting everyone loose brought us to where we are today.
Anybody else have any comments?
I think that I would add, I would agree with 100% of what Ivy said. I would also add that, the idea of what is AI is a moving target. That is, if you would ask somebody in 1980, what is AI? They would have said, I just saw this amazing AI. It's called a spreadsheet. And that's going to put accountants out of business, right? If you'd asked in 1997, I just saw this amazing AI. It's called MapQuest. That turns into Google Maps, right? But the thing is, as we move through time, it turns from AI into just software. So when you ask, we've had AI for years, why is it different today? I would say that it's because our definition of AI has changed over time, and that it is constantly, we're moving the goalposts, that the AI that we say generative AI today, in 5 years from now won't be AI. It'll just be the air we breathe. That is, it'll be like email. It'll be like internet, right? So we won't call it AI anymore. So in the same way, I think that we need to be able to breathe the air of generative AI as it stands right now, because it's going to be with us for a while.
But I wonder if I could just ask, and I agree with what you said, what is the difference other than it's widely available? Isn't there something about the way this particular technology is unfolding that puts it in a qualitatively different stance than email or e-discovery and other things?
Yeah, I would say yes, because this is the first time ever that we've had technology that is able to ingest, analyze, and output language. That is, in the past with with e-discovery things, we've been able to ingest data, right? But we've never been able to reason with data in the way that large language models are able to reason with language. So when you think about what lawyers do for a living, all we do for a living, we ingest words, we analyze words, and we output words. And it turns out that the large language models are able to do all those things really well. So I think that's what makes it different, is that now we're able to
do those things. They can just appear to do those things.
Well,
the software that we've been using, it does ingest data. It does provide some analytical reasoning and draw upon the connections that we've programmed it to do. But now you're using these vectors where you're showing connections in relationship to the words and how the words have been used before. You're not necessarily relying on logical connections, which used to be programmed by some expert. So it's a completely different approach.
Yeah,
So I would
agree.
Yeah, I'm gonna chime in here because I think Damien hit on something to Jayne's question, Ivy, as well. Can I agree with everything? Obviously, we have to say on roundtables that we agree with all each other. No, but yeah, I think one of the fundamental things that's completely different about the new version of AI, right? The generative AI stuff that's come out in the past year is the interactivity of it. And it's not just that it ingests and outputs a lot of data. It does it in such an interactive way with the user. It's really gamifying, language, right? I played video games my entire life. I'm just outing myself, by the way, as a person that played video games, and that's fine, apparently. But 10 years ago, that wasn't cool in the professional context. But when you always talk about the AI engines behind video games, and those really make or break great video games. Why? Because the interactivity of those games. And so when you think about a software that's dealing with language, I agree with Damien. It will become just the air we breathe. Just like video games, we don't conceptualize AI in a video game, but that's exactly what's going on with NPCs versus playable characters. Non-playable characters versus playable characters, and how we interact in a virtual world. Now we're just doing it in the professional language context. I really feel like that's a big differentiator. Is I can have a conversation with a system that is apparently outputting information to me, thoughtful information. When's the last time we had that? Outside of a video game context, I don't remember ever. Even in math, we talk about the new calculator. I don't remember a calculator being able to interact in a conversant way with me to come to the right formula I was searching for in calculus.
Yeah.
Totally different technology. Yeah.
I agreed. And I would also say that the output of these large language models, this is the first time in history that output looks a lot like lawyers' output. That is, they're like, oh my God, this is everything that I do. It's indistinguishable from what I do or from what a first-year associate does, et cetera. So I think that, and Ivy, I think, took an issue with my talking about reason, and I think with good reason that she took reason because there's really a question as to whether it is reasoning or not. But my friend Daz at Greenwood introduced me to a concept called the duck test for coding, for duck coding. And the idea is that with any, computer scientists say, with any of these black box models, the input, but you have no idea what happens on the black box, but then the output, right? But on the output side, if it looks like a duck and quacks like a duck, that's probably a duck, right? So from the output side, if it looks like reasoning and it sounds like reasoning and it's kind of reasoning like a human would do it, maybe it's kind of reasoning.
We're there yet, and I think that jumping to that point at this early stage in Gen AI development is what's leading to a lot of lawyers not questioning the output adequately. We still need that level of engagement and questioning, and we can't abandon our duty of inquiry and advice. So I'm splitting hairs because I want people to develop that judgment and know when they should question rather than immediately accept what they're getting right now. In a year or 5 years, that may be different, but right now they still need to poke around and question and inject their own thought process.
Yeah, I did that. I agree 100%. And I also questioned the thought process of the first year associate and the third year associate and the fifth year associate, right? I do not accept that blindly because I would be not doing my ethical duty as a partner to do that. So much like I would, but I still know that the first year associate reasons, right? So I would say that doesn't nullify the reasoning capability. You still have to check with them, but I would say that it's doing a pretty good job if it can exceed those skills.
But I hate to split hairs here, and I am not an expert on this, but I'm in Ivy's camp here. To even say there's reasoning there leads lawyers down the wrong path. And I take issue with it looks like a duck and walks like a duck. Attorney Schwartz filed a pleading with several cases that looked like they were good. And they were just completely made up because the technology is not reasoning, but predicting the next words and filling in from the big data sets, what you have going with you, Damien, 14 billion. I'll pick this word, I'll pick that word. It's in the right form. There's a V in the middle. There's a year at the end. It's a case. And I think we have to stop and this is one where I think, as Ivy said, the duty to understand the technology is way more important than when you're buying a setup that's not going to change. It is what it is. And it's easier for us to get our hands wrapped around it, right?
Yeah, I would say, yeah, I agree. And I think Mr. Schwartz was doing it wrong, as everyone, I think, agrees that, where there's two ways to use a large language model. One is as an information retrieval device, which is what he was doing. And the other is an ideation machine and as a drafting machine. And so I think that anyone who uses it as an information retrieval is doing it wrong because of that hallucination. But if I'm using it as an ideation machine, that is saying, give me potential arguments. I could argue against the other side. Give me a list of 50 potential arguments. And from that use of 50, I pick 3 that are really good. The fact that it hallucinates doesn't matter, right? Because it's really not, I'm not asking for the information retrieval. I'm asking for ideation. So really, when we think about the use cases, yes, using it for information retrieval is wrong because it's going to do that. But if you're using it for ideations, what are the things that I should be telling my client and thinking about? That ideation side, hallucinations are kind of a feature, not a bug.
Don't think about elephants. Don't you immediately start thinking about elephants? When people think that generative AI will immediately solve the blank page problem, I always worry about the don't think about elephants, because yes, you have somewhere to start, but you may have come up with something better. And I think that's one of the reasons why generative AI is so good at bringing up the low performers who couldn't have thought of anything to begin with, but it's not particularly helpful for the highest performers who would have gotten there on their own and would have come up with a really nuanced argument. So I think we need to sandwich our use of AI or generative AI to get the best result, where you think about the right prompt, you think about where you're going, you give it that context, then you get a result, and then you manipulate that result to meet your needs. If you just jump straight into saying, hey, Gen AI, please give me these ideas and I'll just pick 3, you're missing that valuable part of framing your case and applying your own judgment. Sorry, Kenton, I know that you really wanted to say something.
No, those are great thoughts, Ivy. And what I would also add is, Damien, in a perfect world, yes, of course, attorneys would be so knowledgeable about this technology. Of course, they would only know that they can use it as an ideation machine. But we know that's not the case. And honestly, the firms, including yours possibly, that are producing these tools don't market them as ideation machines. Hey, do you need to draft a demand letter? Just hit this magical button and a demand letter will be drafted for you. And you know what? You don't have to draft demand letters ever again, because our new magical button will always draft the perfect demand letter for you. And then you put the little disclaimer at the bottom. I haven't looked at, sorry, I'm not outing anybody's technology, but it says, hey, watch for hallucinations. Okay, well, if I give that to a first, second, third, fifth year associate, and then they draft the demand letter using that, because they never drafted a demand letter before. I think there is value in the blank page phenomenon. But I agree with Ivy. If you say don't think about elephants, we're going to think about elephants. And if you say also, hey, do X, Y, and Z more efficiently, and here's this awesome tool we just gave you, you're going to try and leverage that tool as efficiently, as effectively as possible. And I think that's what Stephen Schwartz was doing. It wasn't necessarily that he needed to understand the technology. He was acting like most lawyers. Give me the cheapest, easiest way to get to my final work product. And it looks like a duck. It smells like a duck. And you know what? It
turns out
feels
it's
like
tofu.
It turns out it's tofu.
Tofurkey.
Right. But
Well-
I think there's a responsibility, maybe even on the companies producing these for the legal system, to be very honest about what they can be used for and what they are not to be used for. Or if you're going to use them for these other things, make sure you are verifying everything. Because I'll tell you, I teach law students. They're looking for the fastest, most efficient way to get to a good work product. And so we do it in the
I
legal
can tell
industry.
you that I create an expert writing tool, which is WordBreak, and it is not nearly as exciting to say, oh, we can make great writing even better. We'll help you shave 15% off that brief. That is not nearly as exciting than here's an easy button and it'll do it for you. People want the easy button, and it's a world that we have to acknowledge we live in, whether it is the right gut reaction or not.
And I probably want to mention that even though we're lawyers, and so we have this zero fault tolerance as a part of our culture, there's a million things AI does great for you. I had a friend who was going to Savannah, and I said, here, let me run off and who cares if a human expert would have had one of the 15 things that said different or had them in a different order or whatever. So there are a lot of great things you can do with it right now, just not legal work, where we have two basically standards of conduct: perfection and malpractice.
Yeah, I think so too. And thinking about too, there's also an aspect of what will the client pay for. After having litigated for 15 years, I would say that I started practice in 2002, and one of my partners then said, my best legal work is me leaning back and thinking really hard about what could I do, right? And in 2002, the client might have paid for hours of him leaning back in his chair and thinking. So between that as option number 1 and option number 2, asking the large language model, give me 25 different potential strategies that could be doing. That leaning back option 1, maybe that lawyer might have thought of 2 things, but all of a sudden there's 25 that happens in a few seconds. What will the client really pay for? And so I would say the blank page problem. I agree with Ivy that my best thinking comes from when I'm struggling really hard with a blank page and really thinking through that. But even then, I only get the 2 things, right? I don't get the 25. And will the client really pay for the blank page or not?
So
Right.
I will admit, I want to know where the limitations are. I don't just test a tool and decide I don't like something and then never touch it again. I committed to using all of the consumer Gen AI products for 2 hours a day, every single day, and I've been doing it since March. And I will generate and generate and generate. And one of the problems that comes with that is that you get to a point where you've generated so much that you just don't even look at it. And people just say, well, I'm just going to use this. And they've overwhelmed themselves with a mountain of generated information. And then they just use it without that inquiry. So again, we're going back to the ethical duty of advising your client and doing the research and duty of candor to the tribunal and having that judgment. You need all of those things. And there are fast ways to get tools, but I don't think that there's any fast way to, or super fast way to just to serve your client. You can't skip over the lawyering part. You can get a tool quickly, but you still have to be a lawyer.
Well, let's go ahead, Jayne. Let's go ahead and move along a little bit because we've brought up his name twice now. But I think it's really unfortunate that most lawyers' first impression of AI was a certain New York lawyer named Schwartz who used ChatGPT to prepare pleadings and didn't review the cases and was ultimately sanctioned by the judge for his poor judgment. You know, lawyers are trained to be skeptical already. Selling them on something new is always a tough sell. And so I think many lawyers' initial takeaway was, okay, don't use ChatGPT or AI. Is that part of our rigid thinking as lawyers about AI that could cause us to miss the right answer or to conflate risks and benefits? Jayne, why don't we start with you?
I think a natural reaction by many lawyers, I don't know if it's our rigid thinking, but we are precedent bound and we don't necessarily embrace new things. So yes, the minute there's a problem, it's like, oops, let's go back to what we're comfortable with. Let me take out my legal pad and quill and sit down and talk to a client, right? So I think there's that fear of the unknown and we are going to get burned. And then the fear of will this also take away billable hours, which kind of is where we were talking about a minute ago. I'm hopeful that this will cause a re-examination of the billable hour as a measure of lawyers' worth, because it's been a very bad deal for lawyers for a long time. And now it's clear you can't bill for 2 hours if you have a tool that produced that document in 2 minutes. So what are we going to do? So anyway, I think there's a lot of opportunities. I think lawyers are afraid of the unknown. Is it going to take away my work, my billable hours? Am I going to get myself in hot water like these other lawyers did? But, there's a lawyer in Mr. Craybill in Colorado got suspended for 90 days, I believe. Both of those cases, though, the lawyers didn't check their work and then they misrepresented the facts to the court. So, of course, they got slapped. Frankly, I would have slapped them harder if I were the judge.
Yeah, I agree with that, Jayne. So, sorry, Ivy. So those lawyers didn't get slapped for using generative AI products, right? They got sanctioned either by a bar or by a court for misrepresenting something before a tribunal, their usage of the Gen AI, right? And so I really believe that those two examples, Stephen Schwartz and then the young associate out in Colorado, if they had been forthright at the very beginning, they would have never been sanctioned.
I agree.
It has everything to do with the duty of candor, as what Ivy was talking about earlier, towards the tribunal of what you're doing in your work when you get caught. Everybody's been there as a young associate or an older partner where something is in your pleading, maybe because of something somewhere. I had it happen as my second year associate self as a probate proceeding where something was in the file that shouldn't have been there, and the judge called me on it. I didn't know it was in there. My legal assistant literally just handed it to me at the door. And I was like, Your Honor, I have no clue. I got to go figure that out. And he was very appreciative of that, right? And so it was all about the duty of candor. And I think that was, we create a boogeyman out of generative AI because of other ethical issues that these attorneys were having in front of these tribunals. And I, at the very outset of the poor Mr. Swartz, I was just like, that's a legal research question. That is not a generative AI question. Like, read the cases. I talked to my first year students. Everything you do, you need to read what you actually are going to cite to. So go ahead, Davey.
Just a quick thing on that. One of the things that generative AI will do is it'll take a real site and detach it from the thing that it's supposed to be connected to and attach it to something else. And both of those parts can be true, but if you don't site check it, you won't realize that they aren't actually connected. So it's easy to go down the wrong path if you only check one part, and it is your duty to check both parts. And back to the rigidity thing, the thing that I got from that question was that we shouldn't only look at the risks, we should also look at the benefits that are possible. And I think that you are shirking your duty of technology competence if you focus solely on the risks. So as much as I'm a skeptic, I also know that it is my job to see where there are possible benefits. And the other lawyers out there should be looking for opportunities too, because that is the other side of the risk coin. It's the opportunity coin. You've got to look at it.
Go ahead, Damien.
So I agree 100% with that, that the risk and the opportunity, we need to do both. And if we think about, we've been down this path before historically. If I started practicing in 1999 when I was a clerk, and email, there was a question, should you be able to use email or not? And all of the ethics people were saying, no, because it's insecure, because every one of the hops of the servers, somebody could snoop in and be able to snoop in that email. But then everybody used it, and all of a sudden it's okay. And now there are courts saying if you don't check your email, that's a breach of your duty, right? Same thing with e-discovery. No, I need eyes on every single one of these things. But then everybody used it, and all of a sudden it's now shirking your duty if you don't use TAR and other e-discovery. Cloud computing, same idea, right? So this idea is that it is totally unethical until it's not. And then all of a sudden it's now a part of practice.
Yeah, well, I was going to say, Damien, absolutely same idea. Darla Jackson and I wrote an article for the Oklahoma Bar Association Journal a few years ago about the lawyer's duty to actually investigate benefits of technology. And it's not just on the risk analysis, but I do have the, Jayne kind of mentioned it, where if I'm looking for a benefit for my client that is going to reduce how much I can bill my client, I'm now at odds. And, lawyers really need to take a serious look at that and say, what is your actual duty to your client? Ivy wrote an article in 2017 about Microsoft Word, and it's like, if you're not using it correctly, you're overbilling your client, and you are charging an unreasonable fee. And actually, I think you went even further, say you're stealing from your client, if I remember correctly.
Yep, I said that. I still believe
yeah. And I mean, every professional has a duty. We have fiduciary duties to our clients. Like, we need to put I did this in practice when judges wouldn't let us out of cases when our clients weren't paying the bill. Client doesn't pay their bill, you motion to withdraw his counsel, and judge says, no, you're in it to win it. And you've got to bite that bullet. And I think we've got to do that with technology as well. Now, am I saying that lawyers shouldn't make money and we shouldn't earn a living? Absolutely not. I think we have to understand how our business works in a smarter way using these tools, but we have to go investigate it at least. Because I agree, if Jayne hires an attorney that is going to charge her 5 hours to do something that I could do in 15 minutes, leveraging the right tools, who's the more ethical lawyer? And it's verified, and I'm able to review it and provide lawyer advice.
But that's assuming that those hours just go away. And I don't think that's actually what happens. If you are working more efficiently, then you counsel your client and you figure out how they don't wind up in this position next time. how can you change your contract so that people pay? How can you change your intake process so that you don't have as many defaulting borrowers or credit, in anybody? There, you can help your clients change those processes, and there's money to be had there. You become their counsel of record. You become that trusted advisor that your clients are really looking for. So I think we need to stop thinking of it as a zero-sum game, where if we're efficient, we just simply don't have the money. We will have money, and clients will trust us, and then we'll have those long-term relationships. And all of that business development stuff that lawyers hate to do and that just stresses them out so much, I think there'll be less of that if we are trusted advisors to our clients.
Yeah, I would agree with that. And there's what she touched on was a bit of Jevon's paradox. That is, the cheaper something becomes, the more we use of it. So, for example, LED light bulbs, we thought, oh, that's going to save us a ton of time, a ton of energy. But what do? We leave them on longer, so we don't actually save all the energy that we thought we were going to save. So, in the same way, like I build a tool that, if somebody say, oh, that would take me 10 hours to research this thing, but all of a sudden takes me a minute and a half. Where goes the rest of those 10 hours? Well, now I can ask, instead of asking one legal question, I can ask question 2 and question 5 and question 20 and question 50. And now I've answered 50 of those questions in the same time that it used to take me 1. So if I'm billing by the hour, I'm still billing the same number of hours, but I'm giving the client a much better work product, which is just what Ivy is saying. Now I can go beyond what it used to do inefficiently, but now by doing it efficiently, I give a better product to my client.
And I see in solo and small firm practice, a lot of those clients would really appreciate some written instructions accompanying every step of the way to take home with them, so they can, or to read in their phone or whatever. I wrote a couple of books for the ABA on alternative billing many years ago, Kenton. And but back then I thought it was going to be automated document assembly and templates rather than AI, but it's still the same thing. If you can do something in 15 seconds or 30 seconds, you need to do it that way. And probably that needs to be a flat fee to be both fair to the client and the firm.
Yeah, I just want to point out something from Ivy and Damien that I agree with, but I want to make sure it's not lost on anyone listening to this, is what you guys just talked about is creating value for your client and not just padding your bills. So the 50 questions that Damien says that he can actually work through now, right? Is that actually creating value for your client? That's part of that fiduciary duty when you're billing your client, is you got to be creating value for them. It's not just about making the money because you got a better tool to do some more work somewhere else. And that's where, like, alternative fee arrangements are great. Subscription-based models can actually enhance the ability for people to feel free to ask questions of their lawyers, thinking they're not getting nickel and dimed for every phone call. There are other benefits to other types of fee arrangements outside of just dollars and cents for your client. But yeah, I totally agree. If you're creating value for your client, wonderful. That's what we should be doing. And we should be leveraging the tools to create the value where necessary, right? If it, Jayne, harken back to the pen and paper, or the quill and the pad, right? That doesn't create value for my client that lives across the ocean, right? Like, that working that way does not create value for them. So I got to go find the right tools to create the right value for the right client, and then I can monetize that appropriately. But I just want to make sure that's not lost for people listening, of like, oh, I can just keep on doing more work, because that also, there's so many different factors that goes into it. Maybe you're under leveraged on associates, and what am I going to do if AI can do what was it that 3 Geeks came out with in September or August? 44% of work that an associate would do. Well, now that's a different demand, because my associate can't do all that higher level work yet. And so I can't just shift all these hours onto them. Or maybe I can. Maybe we just have this fallacy of what associates are really capable of. It just comes back to that question of what's creating value for a client. And these tools absolutely put that front and center for all of us.
Yeah, and if I could just add on to that, I think it also creates more value for lawyers. So many young lawyers are burned out by monotonous, repetitive grunt work that now can be done more efficiently, by AI products. And it frees up lawyers to do the higher level thinking and client interactions, et cetera. So I just read an article recently, KPMG and some of the accounting firms are right out front that the time to partnership there, and there were some law firms in this article too, was going to shrink. They don't need so many years of doing the same deal. Maybe a couple times they'll get it, they'll move up the ranks. So that'll be better for those who can engage in that higher thinking, which is why we went to law school to begin with. It also is going to cause us all to think about training of our younger lawyers. We can't just assume, yeah, throw them in a warehouse somewhere, I'll let them figure out what privilege is, right? So there's so many facets to this that bring up ethical opportunities for the profession.
That's perfect, because model rules 5.1 and 5.3 are about the duty to train and supervise. And
Yes.
as part of that duty, it can actually connect to all of your other ethical duties. So you can't just say your job is to bill. You also have to say your job is to learn technology. Your job is to do all of these other things. When you are a supervising lawyer, it is your duty to make sure that everyone else is following all of their other duties. And I think that if you're training properly, you've built that into place and you're helping them to grow and develop that higher level thinking. And hopefully with AI, the knowledge that's so hard to pull out of your head and systematize, hopefully it will become easier to capture and share that knowledge, and we'll see knowledge management just amp up on steroids. That's what I'm hoping for. Then it'll be okay that that time to partnership is shorter, because people will still have the resources to turn to, even if they didn't have that direct experience.
Before we
agree with
move
that.
on from training, I'd like to maybe give Kenton a minute to talk about law schools and their role in this situation. Are they going to ban AI, of course, or?
Ooh, all right. So, as the token law professor in this group, so no, every law school is approaching this a little differently. Everyone's got their own flavor of how they're approaching this. Here we have a few baseline rules at OU that basically it's not allowed to be used unless the professor says you can use it. And depending on the course and depending on the professor, you're seeing very different styles of adoption of AI in the classroom. My classroom, I'm actually working with Power Notes right now to figure out how I put AI through what's called their AI Unity project for the spring semester in the tech and law practice course. And I mean, yeah, this goes kind of like into what we were talking about earlier. Students need to learn how to experiment with these tools in a safe place so that when they become the legal professional of the future, they're not completely ignorant of what's going on. And I told my students this in my first year legal research course this semester, this fall. We actually talked about artificial intelligence. We got all four of the publicly available ones: Claude, Bard, Bing Enterprise Chat, as well as ChatGPT-4 and on GPT-4, and then CoCounsel. And we kind of did a little comparison test. What's going on? How do these work? And we went through the issues of information literacy as it applies to these tools to get them into that stage of critically evaluating what's going on, because I do not want them to be in the New York Times. I do not want my students to be in the Daily Oklahoman as the next lawyer that got sanctioned by a court. I wanted them to graduate and have that ability to do that risk-benefit calculation because we gave them a safe space to understand these tools. So that's how we're approaching it at the time, approaching it. Most schools are going that route. Very, very few schools now are saying, oh, just no one can use it. I think those days are gone. I think everybody realizes the ubiquity of ChatGPT and other tools, how it's being built into everything else. It's going to be the air we breathe, like Damien said. And so academic institutions are absolutely facing this head on, and so many different flavors, but no one's ignoring it.
Okay.
But yeah.
I got one thing I really want to cover before we move on, and that's client privacy, confidentiality. I've had several lawyers ask me about their prompts and research and whatever, and is that now being added to a database and therefore potentially revealing confidential information? Kenton, why don't you start the discussion on that one? That's the way lawyers think about things, right?
Yeah, well, hey, absolutely. Just like our email conversation, right? We're so worried about this new technology and what it's doing, and for good reason, right? And obviously, a lot of news. There are steps you can take as a legal professional, depending on the systems that you purchase or sign up for, to safeguard your data, and that goes for not just generative AI products, but any product. Any cloud-based software as a solution product, you have to worry about data privacy and confidentiality of the data, especially data that you input. So I'll tell you, for ChatGPT, what I would suggest attorneys do is I pony up the $20 a month because I think it's worth it, but I also get more control, and more control is good for legal professionals. By the way, all legal professionals using these systems, go into settings and see if you can turn off the ability to upload data. There's little triggers. As I tell my students, if you see a menu or settings, always go investigate what the potential is. Don't ignore that stuff. I don't know where it is that it's probably because of iPhone. I'm going to just out Apple for a second. Just easy to use. It's super intuitive. Don't worry about anything. We got your back. That's how most people approach technology. And I'm like, no, dive into the settings, dive into the options, see what's available. And then also kind of do a little bit of investigation on who these companies are and how they monetize these systems. No brand names on the public market, but there's some that may harvest your data to sell because that's how they monetize their work. And so as a professional, go through the old, I say old, from 2016, the LCCA standards for any cloud-based system, the Legal Cloud Computing Association's 20 standards for evaluating cloud-based technology. Do the same thing with your generative AI tool. I don't know why we would throw out our duty of keeping client confidences just because it's generative AI. We should be doing it with every technology we purchase, and this one's no different.
I doubt there's much disagreement on that point with Kenton. So
None.
I would say what one nuance. Oh, go ahead, Jayne.
Oh, it was me, but go ahead, Damien. I'll go after you.
Okay, so I would agree with Ken that, yeah, of course we have a duty of protecting private information. I would say the nuance and the wrinkle is that here there are so many more chains along the path. So, for example, my company uses generative AI, and of course you give your data to me, which of course I protect and safeguard and say I will not use it for my model. And then I run it through OpenAI, which OpenAI has told me that they're not going to use it to be able to generate their model, right? And I'm also using it for Mistral, and I'm also using Claude, and I'm also using so right. So there's a chain between you and me and all of those, and then back to you. That there is. You really need to know not just who you're working with, but the tools that they're using. And in a sense, when I say your stuff is safe, that is me saying that the people that I'm sending my stuff to have also said that it's safe, right? So there's an aspect of that.
Well, folks, this has been a great discussion. Okay, go ahead, Gabby.
Is that people only think about the transmission and the storage, but you also have to think about how things actually work. So in most of the generative AI tools, unless they're legal specific built and enterprise grade tools, there is a review policy. So humans are seeing what you're inputting. And I would argue that that human review process is actually a violation of your duties. And so you should think long and hard about using those tools, and you should think about their retention policies. So even if it's not going to be incorporated into the training model, someone is still seeing it, you're still disclosing, and there are many elements to the duty to protect client confidences. And I also want to remind people that it's not just confidential information, it's also anything related to your representation that is bound to be protected. So the fact that you're representing a client is information that you should secure. So think about all of those different pieces, not just XYZ company is getting sued for ABC thing. There's so much more there. And as lawyers, it's our duty to understand all of it. And I think that we just think super narrowly as a rule of thumb. And maybe we should think more broadly about that, because we are getting into this far more connected world that that you have less control over. So use tokens when you get started, put in fake names when you are using these, especially if you're using consumer tools. Use fake cities. You're still going to get the same analysis. ChatGPT doesn't need to know that your company is Sony. It's still going to give you the same thing if you put in ABC Corp. So do those sorts of things to give your clients that additional level of protection, rather than relying on what other people say is going to happen for protecting your information.
Well, this has been a great discussion, folks. I really appreciate all of you donating your time. Let's go ahead and close with one more 2 or 3 minute session from everybody. Anything you want to say, your closing thoughts, or a great AI tool that you like that hadn't been mentioned yet, or just whatever. But let's start with Kenton.
Closing thoughts. Man, I say the future is bright. And so, when I say that, we all like to say things like this. The generative AI tools that we're looking at right now are the worst that they're ever going to be, right? Like, they should only get better. And so we should expect better over time. I was having a conversation with some law librarian friends last week, and we were talking about generative AI, and there's a sentiment that this is it. We're done. This is about as good as it's going to get. And I'm like, no, we can't. It may just be the optimist in me, but I really see a future in 5-10 years where this has progressed so much that, like Kevin Kelly from Wired Magazine likes to say in his book, The Inevitable, like, there are jobs that don't even exist now that will exist in 10 years. And in the legal system, we just don't think like that. We think lawyer, paralegal, legal assistant. And now we have this budding thing over the past decade called legal ops. What else is coming, right? Be open to that. I do think the future is bright, and we can see the legal industry really making some huge leaps forward in all facets of the legal industry with this technology, because it is so transformative. So I would say the future is bright. That's my last takeaway. I don't have a tool for you. There's so many out there, but I'm really excited to see what's going to happen over the next decade. I'm looking at Damien because he's going to help develop this stuff. And I think the future is bright for legal, and as long as we kind of understand those benefits along with the risks. But yeah, future's bright.
Damien?
I've got 3 that I'll get out in a minute and a half. Number 1 is that this is not a search tool; it is an ideation tool. So if you that will keep you from schwartzing things up. That's thing number 1. Thing number 2 is that retrieval augmented generation. It's one thing to ask ChatGPT out of the box, give me an answer. It's going to hallucinate. If you say, here's a document, summarize it, the odds of hallucination go drastically down. So retrieval augmented generation is to be able to say, here is a few documents, reason with that. That is going to give you much better results. That's thing number 2. Thing number 3 is that there is a saying in software, garbage in, garbage out. That is, if you ask, give me a motion to dismiss, it's going to give you crap because that's all you asked it. But if you say, here are my legal theories, and give it like 3 paragraphs of what I'm going to be doing for a motion to dismiss, give me ideation based on these 3 paragraphs or 3 pages, because I've given it more information and more context, the output is going to be much better. Still don't use it for retrieve, don't use it for search, but the ideation is going to be much better if you input more information.
Ivy, you want to go next?
Sure. So I'm a big fan of Jurassic Park, and I love the part where Jeff Goldblum says, you were so busy thinking about whether you could, you didn't stop to think about whether you should. And for me, that's a huge thing for people who are super excited about every new technology that comes out. And that's not to say that generative AI won't work. It's just that there's some other tools that are going to be better suited for what you need. For the people who are naturally skeptics, if you ask generative AI to do document automation and expect it to be the same every time, you're going to be disappointed because that's not what it was built to do. Use document automation tools for that. For the people who want to use it for everything, as Damien said, it's not a research tool. So that's my first thing. And then the next is that I think we need frameworks for understanding where the tools we have today fit and how to manage those tools, as well as the tools that we have for tomorrow. And I developed an AI engagement framework where you can shift things along these quadrants that are based on how you manage your inputs and how you manage your outputs and what the sources are that you use. And that should be flexible enough for you today and tomorrow, and should help you develop that judgment that you really need going forward. And if you want a tool that's going to do some really awesome editing for you, let me tell you, WordRake is still the best. Had to get that in.
Jayne?
So I agree with my colleagues that this is a very exciting time to be a lawyer, and the future is bright because of the possibilities and the benefits of generative AI. I also think it is really important, and Ivy has stressed this, to be very thoughtful about what we're doing and why. We talked a bit on this program about value to clients. And I would say we have an obligation as the legal profession to provide value to the public, to those who are not current clients because of the regulations and because it's too expensive. There's a whole lot of roadblocks, and it's frankly an embarrassment to our profession how few Americans get very much needed legal services. So I'm optimistic that some of the new tools can help with that. And that's going to really butt up against UPL and other regulatory frameworks that need to be re-examined. So I think it's time for so many reasons for this profession to step back and look at this tool in conjunction with our values and obligations as a profession. We are at an inflection point, and it's time to really make some whole-scale changes. And I'm excited because I think it's going to happen.
Well, I really appreciate our all-star panel here. Those of you who listen to this now know when we ask these people. The Legal Technology Resource Center is one function of the ABA that is outside the paywall, and you can still access it. And usually they do these roundtables in text format. And so we knew it'd be a lot longer than the normal video you're told you could place on the internet. But I really appreciate all of our panelists. And we're going to apply some Zoom AI tools to this to do summaries and takeaways and see what Zoom comes up with. And we will share that with you as well. So thanks, everybody. Really appreciate you.
Thank you.
Thanks for asking me. It was fun.
Thank you.